Thanks very much, Imelda. Welcome, everyone, and I'd like to acknowledge that we are on the lands that have been held for many, many, many hundreds of years, and we honour those who look after them. I'm not really one for great formalities, although this is a semi-formal event that honours the Frank Kitto series that we have here in law. Last night I was talking to the Chief Justice who came up some years ago, who was very keen to say that he was pleased that one of his great new colleagues, relatively new colleagues, would be here today to talk to us about the ICC. I think we all, at least all of us here, have had an opportunity to understand the importance of having an independent body that looks at actions around the world and deals with the often horrible events that have been going on over the last few decades. So today, I'm not going to tell you about the Honourable Beech-Jones. I'm sure you've all read his rather stunning and illustrious history that brings him to Australia's High Court. So without saying any more, I shall pass it over to our speaker for today. Thank you.
Thank you. Thank you. I too would like to acknowledge the traditional owners of the land on which we gathered, and I pay my respects to their elders, past, present and emerging. Vice-Chancellor, Dr. Moran, men and women of the faculty, thank you for inviting me, and thank you for your fantastic hospitality today. It is a great honour to be invited to deliver the Sir Frank Kitto Lecture at the university at which he served as Deputy Vice-Chancellor and then Chancellor with such distinction, and to deliver the speech in the city where he spent many years until his death. Service was clearly at the core of Sir Frank Kitto's identity, not the least of which was his 20 years of service as a judge of the High Court of Australia. That period of service on the High Court is something I will never reach because the Constitution now prohibits it, and to be perfectly frank, I doubt that I would make it even if I was allowed to. On the 9th of April 1942, Frank Kitto, a 39-year-old, highly respected junior equity barrister on the verge of becoming a QC and with a young family, had another form of service in mind. On that day, he completed his form to enlist in the armed forces and swore an oath to the King. Kitto's application to enlist was refused, and instead he spent 2 years in the Volunteer Defence Force. Kitto is reported as saying how well advised the Defence Department had been in not accepting his offer to become a soldier. In fact, Sir Frank Kitto's moment of greatest service to the nation came 8 years later, when argument commenced in the Communist Party case, being only 6 months after he was sworn in as a Justice of the High Court. Mabo against the State of Queensland No. 2 and the Communist Party case are the two most significant judicial decisions in the history of this country. Justice Kitto was the most junior of the 7 judges that decided the Communist Party case. As we know, the court held by a majority of 6-1 that the Communist Party Dissolution Act of 1950, which sought to ban the Communist Party, was invalid. As most law students lament, the judgment is 156 pages long and all 7 judges wrote separately. However, Justice Kitto's masterful exposition of the scope of the defence power is only 14 pages. His judgment is a salutary reminder to me, the now 7th and most junior judge of the High Court, that the attention of even the most devoted reader will be waning by the time they get to my contribution. So it's best if I make it short and if I make it snappy. I'm sorry, but I have to confess I failed in that objective with this speech. The topic of this speech is Australian domestic law and the International Criminal Court. I chose the prism of domestic law to look at the International Criminal Court because I'm not part of the international law cognoscenti, and even though the domestic law I will describe is almost all in a statute, it has many unusual features. At the outset, can I apologise, especially to the non-lawyers present, for rummaging through the weeds, but in my experience, that tends to be where the action is in the end. The impetus for this topic of this speech is the actions of the United States of America in sanctioning the chief prosecutor and 4 judges of the ICC, something I will return to. Nothing in this speech is directed to either defending or criticising any particular step taken by the ICC in any of its cases, past and present. Like other public institutions that investigate, prosecute and decide, the ICC is open to scrutiny, and the ICC can expect to receive its fair share of legitimate criticism and its unfair share of baseless criticism. However, punitive action against ICC officials, including judges, is of a different order. It is consistent with an escalating pattern of threats and retribution against judges across the world in recent years. Calling attention to that phenomenon is very much the responsibility of those whose function it is to preserve the rule of law, such as judges. One of Kitto's fellow judges who decided the Communist Party case was Sir William Webb. While serving as a High Court judge, Sir William Webb was appointed by General Douglas MacArthur to be president of the International Military Tribunal for the Far East. Another of Kitto's colleagues, Sir Owen Dixon, was Australian ambassador to Washington during the Second World War and was close to many judges of the Supreme Court of the United States, including Justice Robert Jackson. Justice Jackson stood down from that court to become the chief prosecutor at the International Military Tribunal trials in Nuremberg. A former Attorney General of the United States of America was a judge at those trials. Why Kitto decided to try and enlist on that particular day in 1942, and at that time of his life with a young family, is not something that my research has revealed. But history records that by that time, the war was closing in on Australia and closing in fast. Whatever the reason, by the time of his appointment to the High Court, Kitto, like the rest of the judges who decided the Communist Party case, was no doubt very familiar with war and all the horrors it brings, and was familiar with the reason that experienced prosecutors and judges served on international tribunals to try those responsible. I will leave it to your good judgment to consider what Sir Frank Kitto would have made of the sanctioning of prosecutors and judges like Robert Jackson and like Sir William Webb for performing those duties. But now, into the weeds. In June 2002, 2 bills passed both houses of federal parliament on the voices. Hansard records that only 1 member of each house was recorded as having voted against the bills. And one of those who voted against said that he was doing so because he was opposed to installing condom vending machines in Indigenous communities, a reason that will only become more mystifying as my discussion of the content of those bills unfolds. The passage of those bills in that way reflected the fact that they were sponsored by the government of the day and had bipartisan support. Those who can be taken as having supported that legislation included the then Prime Minister, the then Minister for Foreign Affairs, 4 of the next 6 Prime Ministers, and numerous other existing and future frontbenchers of the 2 major parties, as well as almost all of the representatives of the other parties. Like judges delivering judgments, the primary role of legislators is to make laws. Whatever the private or party room misgivings any of those parliamentarians had, this was an emphatic legislative and political statement of support for that legislation and what it embodied by those who governed Australia then and those who would govern it for the next 2 decades. Those bills passed into law. They implemented Australia's commitment to comply with the obligations that it would incur upon ratification of the Rome Statute of the International Criminal Court. The Rome Statute is not a statute in the sense that Australian lawyers understand the term. It is a treaty, specifically the treaty establishing the International Criminal Court and defining its jurisdiction, powers, and the laws governing their exercise. Leaving aside some irrelevant exceptions, international treaties and agreements like the Rome Statute do not become part of the domestic law of Australia. What altered our domestic law on this topic is the passage and entering into law of the 2 bills I described. I will outline the effect of those bills, that is the legislation, in further detail, but in broad terms, those laws brought onshore so-called universal criminal jurisdiction for genocide, war crimes, and crimes against humanity, provided for a complementary but integrated means of enforcement of that jurisdiction through both the ICC and the Australian court system, and proffered to the ICC recognition under Australian law and a degree of protection under Australian law. In the balance of the talk, I'll outline what the Rome Statute is, how we entered into it, and how we implemented it before coming to its effect on domestic law. So what is this Rome Statute to which Australia is a party? The Rome Statute establishes the ICC with the seat of the court to be in The Hague. It's divided into 13 parts, dealing with all the topics one would expect to be contained within a constituent document for a court that has an investigative arm. Those parts include articles relating to the composition and administration of the ICC, including provision for the independence of its judges, provides for investigative, pre-trial and trial procedures and enforcement, as well as the establishment of the Office of the Prosecutor as a separate and independent organ of the court. Part 2 of the Rome Statute deals with jurisdiction and admissibility of investigations and prosecutions for crime. This part can be broken down into 5 parts. What crimes can be investigated, prosecuted and tried? When must they have been committed? Who must have committed them and where? Who initiates an investigation or prosecution? And what about domestic legal systems? The crimes within the ICC's jurisdiction are genocide, crimes against humanity, war crimes, and the crimes of aggression, the meaning of which is described in the statute. The list of crimes against humanity includes the deportation or forcible transfer of a population, being the forced displacement of persons by expulsion or other coercive acts from an area in which they are lawfully present under international law, when that occurs as part of a widespread attack directed against a civilian population. Another crime against humanity is committing inhumane acts to cause great suffering or injury in the course of such an attack. War crimes relating to international armed conflicts include intentionally directing attacks at a civilian population and intentionally launching an attack in the knowledge that the loss of life or injury to civilians would be clearly excessive in relation to the overall anticipated military advantage, that is, disproportionate. To be within the jurisdiction of the ICC, the crimes must have been committed after the statute entered into force in July 2002. The ICC only has jurisdiction in relation to persons over the age of 18 when the crime was committed. Beyond that, the ICC's jurisdiction is best explained by noting there are 3 ways it can be invoked: where there has been a referral by a state party to the prosecutor, where there's been a referral to the prosecutor by the United Nations Security Council, or where the prosecutor has initiated an investigation that has been submitted to and authorised by the pre-trial chamber of the ICC. A referral from the Security Council can be in respect of any territory or national, regardless of whether the relevant state concerned is a party to the Rome Statute. For a referral by a state party to the prosecutor or the prosecutor's own investigation, the ICC can exercise jurisdiction if the alleged crime was committed by the national of a member state or on the territory of a member state. Now, the ICC's jurisdiction over crimes committed on the territory of states who are parties by nationals who are not members has been the source of much friction. From a time soon after the Rome Statute commenced, the USA has been resolutely opposed to the ICC, and in particular this aspect of its jurisdiction, as it agitated to keep its own citizen out of the ICC, including its soldiers who served in Afghanistan or other areas of conflict. The recitals to the sanctions imposed on the judges I referred to earlier asserted that the ICC has no jurisdiction over countries who have not recognised the ICC's jurisdiction and who are not parties to the Rome Statute. Some commentators, who should know better, say the same thing. So what's the significance of domestic legal systems to the ICC? Under the Rome Statute, where the prosecutor initiates an investigation on their own behalf or following a referral from a state party, the prosecutor has to notify all interested state parties, as well as any state, regardless of whether it was a party, that would normally exercise jurisdiction over the relevant crime. That a state may then notify the IC that it's investigating or has investigating its nationals or others with respect to the crime, after which the prosecutor shall defer to that state, subject to certain exceptions. The ICC itself is obliged to find that a case is inadmissible if it is being investigated or prosecuted by a state which has jurisdiction over it, unless that state is unwilling or unable to carry out the investigation or prosecution genuinely, or if there has in the past been a genuine investigation and a decision not to prosecute, or there has been a proper trial. Can I emphasise that the language of the statute is being investigated, has been investigated, or has already been tried. The fact that a crime could or might be investigated by a state does not remove it from the ICC's jurisdiction. These parts of the Rome Statute embody the principle which was at the forefront of Australia's accession to the statute, known as complementarity. That being the notion that the ICC complements and does not supplant domestic jurisdictions so far as prosecuting and trying allegations of genocide, war crimes, and crimes against humanity are concerned. One myth about the ICC is that the existence of a fully functioning and fiercely independent legal system within a particular country is sufficient to deny the ICC jurisdiction over crimes committed by its nationals. That is not sufficient. Instead, the inquiry is fact-specific, and as I said, depends on whether there has been or is a genuine investigation, decision to prosecute, or trial. You cannot have a trial without an investigation and the bringing of a prosecution. Australia has a functioning independent legal system, of which I've been part of as a judge for over 13 years. In that time, I've not conducted or caused to be commenced any investigation into anyone or authorised any prosecution. For many countries, this country included, a functioning and independent judiciary is not of itself sufficient to ensure that crimes of the kind covered by the Rome Statute, allegedly committed by members of the armed forces, senior government officials or others, are properly investigated and, if appropriate, prosecuted. Instead, executive agencies perform whole or part of that function. However, in some countries, the investigative agencies are inadequate, compromised, or at least simply not engaged in relation to a particular person or class of persons who might be accused of a crime. Part 3 of the statute deals with the general principles of criminal law to be applied by the ICC. Any immunity enjoyed by a head of state or member of government is abolished. Military commanders and other superiors bear criminal responsibility for crimes committed by forces under their effective command or control in certain circumstances. The fact that a person acted under superior orders does not relieve that person of criminal responsibility unless he or she was under a legal obligation to obey the order, did not know the order was unlawful, and the order was not manifestly unlawful. So when and how did Australia become a party to the Rome Statute? A history of international criminal tribunals is well beyond the scope of this lecture. So I'll just pick up the story in December 1996, when the relatively new Howard government declared the establishment of the ICC to be one of its, quote, prime multilateral and human rights objectives. By that time, the work on a draft of a treaty that was to become the Rome Statute was well underway. Between June and July 1998, the United Nations Diplomatic Conference in Rome finalised and adopted the Rome Statute. A delegation from the Australian government attended. Australia signed the Rome Statute later that year, but it didn't ratify the treaty until well over 3 years later, after the passage of the bills to which I've referred, and just as the Rome Statute came into effect in July 2002. In the meantime, the Rome Statute and the draft of those bills that I referred to that implemented the statute was subject to a thorough process of review by the Joint Standing Committee on Treaties, which conducted public hearings around the country. By 11 April 2002, a sufficient number of countries had signed and ratified the Rome Statute to enable it to come into force on 1 July. And so the clock was running if Australia wanted to become an original state party. Between that time, that is 11 April and 1 July, the Joint Committee reported to Parliament, those bills were passed, and Australia notified its ratification. I just note 3 points about the process of Australia's entry and implementation of the Rome Statute. First, in 1998, the Australian Foreign Minister addressed the Rome Diplomatic Conference. His speech expressed strong support for the ICC and outlined Australia's position on a number of key issues, including complementarity and the means by which the ICC's jurisdiction would be enlivened. On complementarity, the speech articulated what was ultimately reflected in the Rome Statute that I said earlier, namely the primacy of domestic jurisdictions, but the capacity of the ICC to act where those systems do not address alleged crimes by way of investigation as well as prosecution. The Minister for Foreign Affairs also expressed Australia's support for the ICC prosecutor to be able to directly initiate investigations, that being the feature that was incorporated into the statute and remains. Second, consistent with the Joint Committee's report, upon ratification, the Australian government submitted a declaration which, amongst other things, reaffirmed the primacy of our domestic criminal justice system in relation to crimes within the jurisdiction of the ICC, stated that no person would be surrendered to the ICC until Australia had the full opportunity to investigate or prosecute any alleged crimes, and stated that under Australian law, no one would be surrendered or arrested without a certificate of the Attorney-General of the Commonwealth. There has been debate amongst international lawyers about the effect of such a declaration as opposed to a reservation to a treaty. The consensus appears to be the declaration has no real effect. The Rome Statute operates as it says. For domestic law, the answer is probably the same, save that the declaration is a historical fact that may provide some context to the interpretation of those two bills that were passed. The capacity of the declaration to inhibit the exercise by the Attorney-General of the discretion conferred on him or her by the legislation is tenuous. Third, a recent article indulged in historical revisionism by accepting a description of Australia's accession to the Rome Statute as a, quote, burst of idealism. The process of accession and implementation was no burst. Instead, it was enthusiastically yet carefully pursued by the Australian government over 6 years, and it culminated in emphatic support from almost the entire legislature. When both the executive and the legislature cooperate in the establishment of a body, confirm its independence, arm it with powers, and accept that it can be called a court, then they also have to accept from time to time that court will make decisions with which they disagree. So what were those two bills that passed and came into our domestic law? Well, first, there was the International Criminal Court Act, which was intended to fulfil Australia's obligations under the Rome Statute, but as per the Declaration, was expressed not to affect the primacy of Australia's right to exercise its jurisdiction with respect to crimes within the jurisdiction of the ICC. The International Criminal Court Act addressed such matters as dealing with the requests for arrest and surrender of persons to the ICC, the issue of search warrants and arrest of persons wanted by the ICC, the freezing of proceeds of crimes within the jurisdiction of the ICC, and the enforcement of sentences imposed by the ICC in Australia, including imprisonment. The Act enables the ICC prosecutor to conduct investigations in Australia and the ICC to conduct hearings in this country. The Rome Statute itself is an appendix to the Act. Consistent with the Declaration, the obligations to assist the ICC embodied in that legislation were qualified by reposing in the Attorney General of the day various powers, including what is described as an absolute discretion to issue a warrant for the arrest and subsequent surrender of a person to the ICC. The other bill that passed became the International Criminal Court Consequential Amendments Act, and that inserted Division 268 of Chapter 8 into the Commonwealth Criminal Code. The Attorney General described the effect of those amendments as making every crime under the Rome Statute also a crime under Australian law, so that, quote, Australia will always have the option of prosecuting persons under Australian law rather than surrendering them to the ICC. Now, Division 268 achieves this by codifying into domestic Australian criminal law offences for genocide, crimes against humanity, and war crimes. Although there had been counterpart crimes invoking universal jurisdiction on the statute books for many years, the definition of those crimes was expanded and modified. Thus, the provisions of Division 268 make the crime against humanity of deporting or forcibly transferring one or more persons as part of a widespread or systemic attack against the civilian population a crime under Australian law, punishable by a maximum term of 17 years. Similarly, the crime against humanity of causing great suffering by means of an inhumane act as part of such an attack is made a crime punishable by 25 years imprisonment. Division 268 also makes war crimes of the kind I mentioned earlier, including attacks upon civilian populations and displacing civilian populations for reasons other than their safety or military necessity, crimes under Australian law. Division 268 makes similar provision for command responsibility and superior orders as the Rome Statute. Unlike the Rome Statute, the division does not expressly address head of state immunity and the immunity of other officials of a foreign state, instead leaving that issue to be addressed as a matter of statutory construction and by case law as occurred in the United Kingdom in Re Pinochet No. 3. Three particular points should be noted about Division 268. First, all the provisions of Division 268 designating genocide, crimes against humanity and war crimes to be offences invoke so-called universal criminal jurisdiction. That is, they apply to all conduct engaged anywhere in the world and regardless of whether any result of that conduct constituting the offence occurs in Australia. Somewhat ironically, in view of the various criticisms of the ICC for exercising its jurisdiction, these provisions have a wider application than the Rome Statute, which can only extend to the conduct of nationals of countries that are not parties to the Rome Statute. In the circumstances I described earlier. As we will come to, provisions of Division 268 have been held to apply to the actions of US officials on US territory in civil proceedings in a domestic Australian court, even though those officials themselves may not be amenable to the jurisdiction of our civil courts. Second, consistent with the declaration, criminal proceedings for offences under Division 268 cannot be commenced without the written consent of the Attorney-General. However, as I'll seek to explain, the existence of the Attorney-General's consent is not necessarily the final word on the legal significance of these provisions. Third, it's important not to lose sight of other provisions of the Criminal Code that extend criminal responsibility to those who aid, abet, counsel, or procure the commission of such crimes, and in particular, I emphasise those who urge the commission of such crimes. It may be that at one time we conceived of genocide, war crimes, and crimes against humanity as arising out of a, quote, quarrel in a faraway country between people of whom we know nothing. However, in the current age, these atrocities are packaged, repackaged, and sometimes sanitised for us in ways that can blend reporting, commentary, and outright propaganda that occasionally gets very close to urging the conduct on. The effect of these provisions of the Criminal Code is that under the law of Australia, when it comes to genocide, war crimes, and crimes against humanity, no one, anywhere, gets to barrack that conduct on from the sidelines. So far, I've only referred to those parts of Division 268 that concern genocide, war crimes, and crimes against humanity. But there was another set of crimes introduced by the Consequential Amendments Act, namely crimes against the administration of the justice of the ICC. This set of crimes includes conduct often designated when a court is established, such as perjury or corrupting, impeding and threatening witnesses. These provisions are all consistent with Parliament's recognition of the ICC as a forum for justice sitting alongside our domestic courts. Of particular significance is the protection given by Division 268 to officials of the ICC, including its judges. Thus, it is a crime under Australian law, punishable by a maximum of 5 years imprisonment, to, quote, cause or threaten to cause any detriment, end quote, to an official of the ICC because of their actions as such or the actions of another official of the ICC. This provision does not have precisely the same width of application as the other crimes I've mentioned, but its geographical application is still vast. I won't survey its precise metes and bounds, but it's sufficient to state it does not render criminal the conduct of a foreign government official or official who is not an Australian citizen carried out in a foreign country. That's not an offence. That is not an offence under the laws of that country. However, at the very least, the provision applies to the conduct of all Australian citizens, no matter where they are, including their actions in, say, urging or assisting a foreign government to impose detriments on ICC officials, including judges. For those Australian citizens working for foreign governments, the question of their amenability to the jurisdiction of our civil courts and tribunals is complex. However, no such difficulties apply to Australian citizens working here and overseas for foreign media organisations. The point is, no Australian citizen, no matter who they are and no matter where they are, can involve themselves in punishing or threatening ICC officials, including its judges, or in urging others to do so. It has now been 23 years since the ICC came into being and the bills that I've described came into law. Over that time, the ICC has commenced a number of investigations, most of which have been completed. Many persons have been tried and some have been convicted. Much has been written and said in the law journals and the media about those cases, the ICC and its personnel. However, my concern is with domestic law, and that has been quieter, but not without its developments. In terms of domestic steps that satisfy Australia's obligations under the Rome Statute, there have been and continue to be special inquiries into the actions of various Australian Army personnel in Afghanistan. To my understanding, there is a prosecution of an Australian serviceman under the provisions of Division 268 currently before the courts, and nothing in this speech bears on that case. The inquiries that I refer to reflect the proper understanding of the complementarity principle. In the absence of a proper investigation into alleged war crimes, then the ICC's jurisdiction would have been potentially triggered, regardless of how functional and independent the Australian judicial system is considered to be. However, one particular judgment in a civil case raises some significant issues about the potential for Division 268 of the Criminal Code to bite and bite hard, regardless of whether or not the Attorney General of the day thinks anything should be done about it. At the outset, I should disclose that for a period, I was counsel for the plaintiff in the case in question. What follows is derived from the law report of that decision. Mr. Mamdouh Habib, a dual Australian and Egyptian citizen, was captured and then detained in Pakistan during October 2001. He claimed that he was, to use the language of those times, the subject of an extraordinary rendition to Egypt by US personnel. He was then transported to Guantanamo Bay, where he remained until his release in 2005 without charge. Mr. Habib sued the Commonwealth for the tort of misfeasance in public office. He alleged that Commonwealth officers were involved in his interrogation in Pakistan, Egypt, Afghanistan, and Guantanamo Bay. He alleged that in doing so, those Commonwealth officers aided and abetted the commission of criminal offences by Pakistan, Egyptian, and US officials, that is, specifically breaches of the Crimes Torture Act of 1988, as in force until June 2002, and then reenacted in Division 268. All of those provisions invoked universal jurisdiction, that is, they prescribed torture committed by public officials or persons acting in an official capacity anywhere, irrespective of their citizenship and the identity of their home government. It's important to note Mr. Habib's complaints were only allegations. The proceedings ultimately resolved and no trial was had. Prior to that resolution, the Commonwealth moved to strike out the case, and a question was referred to the full court of the Federal Court of Australia as to whether the proceedings were non-justiciable or otherwise not maintainable because of the operation of the Act of State doctrine. The Act of State doctrine is a common law doctrine which precludes the courts of one state passing judgment on the legality of the actions of another state or its officials, at least on the territory of that other state. Mr. Habib's pleaded case required findings about whether US, Egyptian, or Pakistan officials acted unlawfully in their own countries when they allegedly tortured Mr. Habib. The full court of the Federal Court unanimously held that the Act of State doctrine did not preclude Mr. Habib's action. There was no application for special leave to appeal to the High Court filed against the decision, and thus the court of which I am a member has not considered the matters it raises. What follows is not the expression of any view by me one way or another on those issues, but instead what is significant is the conclusions reached on those issues by an intermediate court of appeal. There were two paths of reasoning of the full court, but it's sufficient to note one of them. All members of the court held that the Act of State doctrine does not prevent a court mentioned in Chapter 3 of the Constitution, and which is exercising the judicial power of the Commonwealth, from determining an allegation that Commonwealth officials acted beyond the bounds of their authority under Commonwealth law. Justice Jago explained that regardless of whether the consent of the Attorney General had been obtained, provisions such as those in Division 268 establish a legal standard by which Parliament considered that conduct, including the conduct of foreign officials acting outside Australia, can be the subject of judicial determinations by Australian courts. Her Honour concluded that those provisions limit the power of Australian officials who might have assisted those foreign officials in that, quote, whatever else the Commonwealth and its officers might do in exercising those powers, they may not act in breach of Commonwealth statutory prescriptions, end quote. When we take this aspect of a bib and look at the provisions of 268 that I've outlined earlier, it can be seen how legislative statements of what constitutes a crime can transcend any restriction that might be placed on the prosecution of those crimes by requiring the consent of the Attorney-General. According to Habib, the substantive operation of Division 268 is a limit on executive power, including the power and authority of government ministers, officials and the military. On that view, they have no power or authority to assist or urge anyone, including a foreign state or official, to engage in conduct that amounts to genocide, a war crime, a crime against humanity, or to impose a detriment on ICC officials, including its judges, for doing their jobs. The executive and its officers, including its ministers, officials and the military, are all amenable to the jurisdiction of the courts in Chapter 3 of the Constitution. Beyond that, a statement of what constitutes these type of crimes is also a statement of a normative standard, and that is so regardless of whether the Attorney-General has or has not consented to a prosecution. All of us should comply with the law, regardless of whether we agree with it, and regardless of whether we think the Attorney-General will or will not consent to us being charged. Some classes of professionals have particular obligations to uphold the law, such as lawyers admitted to practice. They are answerable to their professional bodies and the courts that admitted them to practice. The oath or affirmation that young lawyers take before the Supreme Courts of their respective states and territory has meaning. So where are we now? As I previously said, criticism of a body like the ICC, including its judges, is one thing. Punitive action against officials, including judges, is another altogether. In February 2025, the US government imposed sanctions on the ICC's chief prosecutor. On the 5th of June, that government did the same against 4 judges of the ICC, being judges from Benin, Uganda, Peru and Slovenia. Each of those judges was either an experienced lawyer, a prosecutor or a judge prior to their appointment as a judge of the ICC. Those sanctions preclude those judges and their families from travelling to the United States. The sanctions freeze any of the judges' US-controlled assets. The sanctions prohibit all United States persons from providing foods, goods or services to them, including donating any food, clothing or medicine, quote, intended to be used to relieve human suffering. The sanctions preclude any such judge from receiving funds, goods or services. The penalties for the breach of these sanctions can be severe. The definition of United States persons is very wide, but it's enough to note that it includes any US citizen, US permanent resident or US company. Heaven help any of these judges if they are taken to a hospital that employs an American doctor, try to buy pharmaceuticals from an American pharmaceutical company, or even attend a restaurant that employs an American waiter. The position becomes ridiculous for the doctor or the waiter if they happen to be a dual American and Australian citizen, or the pharmaceutical company if it has an Australian branch. They all may be faced with a choice whether to comply with the US sanctions or Division 268. Similar sanctions have been imposed by the US government on a Brazilian judge. The evidence suggests that was done as a response to judicial acts performed by that judge in Brazil. Threats have been made to impeach judges of US domestic courts for injuncting various actions of the US government. Given that context, I will leave it for you to consider whether the sanctioning of the ICC, including its judges, is something peculiar to that institution, or whether it reflects a larger strategy, or at least a trend directed to the court and to judges. The decisions of sovereign states such as the USA are matters for them. However, extracting vengeance on judges with whose decisions we disagree is anathema to our constitutional arrangements, and in the case of the ICC is contrary to our law. And as I've sought to explain, that law has a long reach and extends to at least Australian citizens who urge the vengeance on, and not just those who impose it. Those laws are binding on at least all Australian citizens, regardless of where they are, regardless of what they do and who they work for, and regardless of the attitude of the Attorney-General of the day. Based on the reasoning in Habib, even absent any consent of the Attorney-General, those laws restrict the powers of all arms of the executive government and may also have consequences for those with professional obligations, most notably Australian lawyers admitted to practice, even if they're not practicing as such. But in the end, this aspect of the lecture is not about the weeds of the law that I've dragged you all through, and it's not about high-minded principles of constitutional or international law, and it's not a discussion that is limited to any particular lawyer or particular judge. In the end, it reduces to a simple question that can arise on any Saturday during winter across the country. Do you accept the umpire's decision, perhaps through gritted teeth or with a grumble, or do you take it further and hunt the umpire down after the game? The answer to that very mundane question, I don't think, is particularly difficult. But as I used to say to juries, in the end, it's a matter for you. Thank you for listening.
Thank you, Your Honor, the Honourable Justice Thomas Beech-Jones, for that very comprehensive, illuminating lecture on the implications of Australian accession to the International Criminal Court. And of course, he had shown to us the messy relationship, the tensions between politics and law, but also on how it has become politicized at this current age and time, considering the impetus and the rationale for the enactment of the International Criminal Court and the International Criminal Court in Rome. So we now open the floor for question and answer, and so. And I can see already some raising their hands. So please, if you have questions in person here in Armidale, on site and online, please raise your hands. I will give the microphone to you, and please identify yourselves first and your institution. So we have here, of course, I know this person.
Professor Cameron Moore, thank you very much, Judge. I found that fascinating and very timely. Conscious of your position, but nonetheless, I think this is a question you might hopefully be able to answer. It seemed to me that in 2002, when the bills passed, people were thinking about foreign warlords. I think it was yesterday that a former SAS trooper was committed for trial for the war crime of murder. And I think that there are going to be sections of the Australian public that are going to find that quite difficult to take. And I'd just be grateful for your views on how we as lawyers should respond to that sort of criticism that that's not what they had in mind when we enacted the relevant legislation. Thank you.
Given the context is of a particular case, I think I'll pass on that one. I'll simply say that I think when people talk about these, that there's a spectre of treaties, foreign committees and all this. That's part of the political realm. People have that debate. My point and why I focus is on this was laws passed by the Australian Parliament with emphatic, bipartisan, almost unanimous support. They, through the democratic process, via the treaties, exactly how laws are made and should be made. And that's what I focused on, and that's what I've outlined. But I think I'll keep away from a particular case or speculating about what the public might or might not think.
Any other questions from the audience? This is a very contentious issue given recent developments. So maybe I should probably ask some question to His Honor. So I'm just, this is a subject that's quite also very close to me. I come from the Philippines, and we actually have, a president now being tried under the ICC. And you mentioned the principle of complementarity, which is now, under contention in the Hague. So you mentioned about the primacy of Australian domestic law in terms of taking control of proceedings involving those crimes enumerated in the statute. But do you think that under the complementarity principle and given the status of Australian domestic law, do you think that we have sufficient safeguards or procedures to actually effectively prosecute those crimes under domestic Australian law? And considering, for example, criminal procedures, it can be in conflict with some procedures of the ICC, for example, in terms of requests for arrests, the request on the Interpol. There are also jurisdictional kind of matters that might be different in Australian criminal procedure, and how this might conflict with ICC?
So when I was preparing this, that's why I moved to domestic law, because I said I'm not part of the international law cognoscenti. It's not meant to be. It's meant to be a mild jibe, because some of my friends are part of the international law cognoscenti. But the books on international law you could probably stack on that table just about these areas alone, and I kept away from them. So I do not in any way what the international law view is of what is a sufficient or not sufficient prosecution is something I'm not really going near of. I'm not aware of any particular class or person or individual or defect in our arrangements looking prospectively that would suggest that you'd say, well, that state that we are unable to do with it. But what I try to say in these speeches, my understanding is it's fact specific. So it's going to arise in relation to a particular person, and not just a statement says, well, you've got a great judicial system. Say Australia has a great independent legal judicial system. Ergo, complementarity can never be triggered. That's not how it works. It's a particular inquiry about what happened with a particular person or class of persons. Looking forward, I'm not going to speculate as to whether in the future there would be something that wouldn't be triggered. I'm just not in a position to do that.
Thank you. Here we have a question. Okay. I thought you were pointing to.
Oh, I thought one of these gentlemen.
Yes.
Thank you, Judge Guy Charlton from Armidale. I have a question, I guess it's dear for all law students, and I'm sort of curious myself coming from a different jurisdiction. On the High Court, the judges seem to write separate opinions. On other courts, other high courts in the United States or in New Zealand or Canada, they tend to write more unified opinions. And I guess, one, from a law student's perspective, why do they do that? Because it is 155 pages and not 30. And two, is it part of the discussion that you have in your interdecisional processes that this comes out of that?
I think the Chief Justice has talked about this, so that gives me cover to say at least what he said. The problem of 7 separate judgments is a real issue, and it's not just for law students, but I hear you. I hear their pain. It's actually a problem for lower trial judges and who have to apply them, having been one. And they're as big an audience who the High Court is addressing as anyone else, because the bulk of our decisions are really trying to give assistance to the lower courts. It is the decision you must make at every point in time. Will I sign on to a majority judgment or a joint judgment that I'm comfortable with, consistent with my oath, knowing that is can be if the judgment's good, you agree with it and think it's workable and the principles are right, or do I think to fulfil my oath I have to write separately because I can't agree with this, or I think there's some particular issue. So there is, I think, if you look over the last 5 years, there has been a fairly significant uptick in the number of joint judgments, certainly at least a majority judgment, or at least a plurality judgment that's representative of what the reasoning of the court is. So it's something we think about and discuss a lot. And each of us, I can't speak for my other 6 colleagues, to my observation, all of us give a lot of consideration to that very thing, each with different philosophies about how far they're prepared to agree to a decision. I'll never agree to a decision I don't agree with. The real question is, will the scope of the decision be narrowed so that we can all agree? That is the debate. Signing on for something you don't agree with, you can't do.
Thank you, Your Honor. I think we will have, and then after that, we have also a question online.
Yeah. I can hear you. Yeah.
You emphasised throughout your paper the bipartisan nature of the way that 2 statutes were passed in 2002. I was just wondering if those 2 statutes came before the Parliament today, do you think that they would pass with the same bipartisan spirit?
I know this is a cop-out, but I just can't answer that question as a judge. I certainly can't answer that, so I'm sorry.
Yes.
Yes, we have someone online. Elizabeth, you have a question.
Thank you. Firstly, I'd like to really thank Justice Thomas with his surname.
Sorry, Elizabeth, can you repeat that question for us?
I should identify myself, shouldn't I?
Yes, please.
Okay. I'm an adjunct senior lecturer with the School of Social Work in the Department of Rural and Remote Health. And I wanted to really thank the Justice for such a clear and accessible outline of this really important information. I do want to say in social work, we have a subject about law, but we rarely go to this international level. And I would like to suggest, if this recording is available, that it be made available to social work students.
Thank you. I have various powers as a High Court judge, but I don't think I've got that power. I think I'll leave that to the university.
But
yes.
you'd be happy for it to be made available.
Once it's out, as the saying goes. I can say this paper is, you'll be shocked to learn I read this out, and it will be, my poor associates are now just editing my terrible grammar and my terrible footnoting. It will be available on the High Court website, and it'll be made available as part of the university's set of lectures, probably sometime next week, knowing how much poor work. But in terms of the making of the video available, the
power is with you.
It's the university's baby now.
Thank you.
So do we have okay, we have one more question. Maybe Greg's the last question.
David Bruce, resident of Armidale. Have Australian judges served on the ICC?
I think the answer to that is yes, they have. I can also tell you that a fellow a woman I was at law school with is the senior appeals counsel on the ICC. She luckily has not been sanctioned, but Australian judges have in the past served on the ICC. They also served on going back a bit, and I do know this. I think prior to the ICC, it came out of particular tribunals that were set up looking into Yugoslavia and Bosnia, and they took that model and then moved it forward. And there were a number of Australian judges who served on those bodies. And as I said, if you go back to the Far East, which tried the senior military leadership of Japan, the Australian High Court judge was the president of that tribunal.
Do we have a final question from the audience? Yes, the guy up there.
Thank you, Judge. John Harris is my name. I'm a local criminal lawyer. I'm very interested. You talked about the power of the prosecutor to bring an investigation. I'm just interested in the interplay of how that investigation takes place on the ground. Does the investigator, for example, I was fortunate recently to meet the chief of the cyber investigation unit for the federal police, and they have their role in terms of disrupting international crime. But does the prosecutor have the capacity to bring in resources to bring their prosecutions in, or do they get police assistance from local police, or how does that on the ground happen?
I'm only really doing this based on no more than going to a few seminars. I don't claim any expertise. I do know, yes, they do have the capacity to bring resources. I heard a discussion about the investigation on the ground in the Ukraine. I think it was to do with the downing of the aircraft. I'm not sure. And they definitely had investigators, forensic investigators on the ground. Now, whether they do that by seconding various members of national police forces, I think that was the model they used there. I don't know, but I think that was what happened in Ukraine. How they do it from one investigation to another. Clearly, there would be no doubt many of their investigations that the going into a particular territory, which various ones we can think of, and I'm not talking about any current ones in the past, it would be extremely difficult, but they have various ways of doing it. They have to, as I understand it, there's a fair amount of evidence prepared at the pre-investigation stage, so they're obviously going through various sources. But I say that this is more as an interested amateur about their processes. I mean, I really moved away from whether I'm saying anything good or bad about the ICC, not because I don't think that's really my role. My real point was to emphasise I have had a long involvement. I used to be president of the Australian Judicial Officers Association, and basically the biggest thing in that was whenever there'd be a scouring article about a judge for a particular decision, and our role was not to say the decision was good or bad, but to say, look, it's one thing to say you disagree with the decision or it was a terrible decision. It's another thing to these personalised attacks on judges, because that's effectively over the line, and it actually undermines our judicial system when you develop to this sort of personal level. And the essence of this speech is it's not about, for me, to say whether a particular decision of the ICC was a good one, a bad one, whether they got jurisdiction right or wrong. I'm not going anywhere near that. It's not any part of my function. But sanctioning judges, contrary to our law and contrary to our constitutional arrangements, and that, I think, is a principle that I think most people would accept.
Thank you, Justice. I think I've seen one raise from this from this row. No question.
Okay.
All right. I think with that, I think that concludes our question and answer. If there is no more question, so. Thank you again, Justice, for that very engaging, very thoughtful discussion, sharing with us your innermost thoughts on a very controversial topic. But with that, let me please join me in thanking expressing our appreciation for that very insightful speech. And of course, last but not the least, the closing remarks from our Deputy Head of School, Associate Professor Guy Charlton.
I don't know if I speak with this or with this, I guess. Thank you, Judge. My name is Guy Charlton. I'm the deputy head of the law school. Our head of the law school, Professor Alpana Roy, gives her apologies. One of the things with the Kitto lectures and also the Kirby lectures here is that this has been a long-standing set of presentations we've had here at uni that stretches back. And the idea of these lectures is to allow staff and students and the Armidale public to have some sort of access and be able to engage in discussion related to contemporary legal issues and legal issues that may be historical. And I'd like to thank, first of all, Greg Karn and Imelda Denla for bringing the judge here and the hard work of all of our staff, our legal staff, Belinda, Lynn, Kath, Caleb, don't want to miss anybody, Anna, and all whom I haven't missed, who I have missed. And I'd also like to acknowledge that our Vice Chancellor, Chris Moran, who's here. I saw him yesterday slogging through the mud at AgQuip, and I'm glad you made it back because it looked quite thick when we were leaving. So one of the things that law must do is law must be understandable and reasonable for all of us as citizens. If the law is not reasonable, how can we be expected to follow the law and to understand the law? It's crucial to our living in a democratic society. And I think that these Kitto lectures and Justice's discussion assisted that, despite the fact we as lawyers and legal academics try very hard to make the law impenetrable. As well as you have to pay me to devise how to make this more understandable, not less accessible. So, and that's really an important aspect of these Kitto lectures. And in particular, to touch on your comments today, the rule of law is under threat. And we discussed there's a discussion about going after judges. And democratic norms are being undermined across the world. And it's not limited to several jurisdictions. It's across the world. And people should know better. Lawyers should know better. And it's crucial that we not only know better, but that we act better. And the High Court and you, Justice Beech-Jones, are on the coal face of this. This is something that we should not forget, that the judges in the courts in each democratic country and in Australia are at the coalface making sure that the rule of law and democratic norms continue to operate. And we have an obligation, in my view, to ensure that continues. And one of the things that we need to understand about rule of law is that law is not simply about solving people's problems. That's what my father always said. Law is about solving people's problems, sir. Son. It's not simply about determining the authority of democratic institutions or the scope of an administrative institution, but it's about justice, and it's about democratic rule and the rights of people to rule themselves. And thank you for reminding of this in this very timely speech. And I'd like to give everybody give a hand, Justice, and thank you again. And you're welcome back to UNE anytime you wish. Thank you.